Guys, in previous lecture we have studied insult and art number 158, and now we will study exposure of personal and family circumstances. So continue with the first paragraph. Art number 161. Whoever asserts or circulates any matter concerning the personal or family life of another person which is capable of injuring that person's reputation shall be punished by a fine or by imprisonment of up to 3 months. If the offence under the preceding paragraph has been committed through the press, radio, television, or other means of public connection or at a public assembly, the perpetrator shall be punished by a fine or by imprisonment of up to 6 months. If what has been asserted or circulated is of such a nature that it brings about the grave consequences for the damaged person, the perpetrator shall be punished by a fine or imprisonment up to 1 year, except in cases under Part 5 of this article. It shall not be permitted to prove truthfulness or untruthfulness of what was asserted or circulated from the personal or family life of another person. Whoever asserts or circulates any matter concerning the personal or family life of another person in the exercise of an official duty, political, or other social activity, the defense of any right or the protection of justified benefits shall not be punished, provided that the defendant proves either the truthfulness of his assertion or that he had a reasonable ground for believing in the truthfulness of what had been asserted or circulated. Accusing another of a criminal offense with the intention of disparage. Art number 162. Whoever, with the intention of disparage, accuses another person of having committed a criminal offense or having been convin- convicted for the same, or whoever communicates such a fact to a third person with the same intention shall be punished by a fine or imprisonment up to 3 months. If the offence under the preceding paragraph has been committed through the press, radio, television, or the other means of public information or at public assembly, the perpetrator shall be punished by a fine or imprisonment of up to 6 months. I have to point out that despite the guidance, directives, and instructions of the Council of Europe arguing that defaming and invasion of privacy belong in civil law and have no place in the criminal code, Slovenian legislature, however, has maintained these torts as criminal offences in professional publications. I have repeatedly pointed out that de lege ferenda is not to protect privacy and good name against the media in criminal law, but only in civil law. However, in the possible assessment of the constitutionality of these provisions, the Constitutional Court will have the last word, although it already ruled in 1999 that these provisions are in accordance with the Constitution. 17. I would also like to point out a specific offense which is intended to protect right to privacy. This is the abuse of personal data from Article 143. Abuse of personal data. According to this provision, whoever uses personal data which are handled according to some act to law inconsistent with the purpose of collection or without the consent of the person to whom the personal data relates shall be punished by a fine or imprisonment of up to 1 year. Consequently, whoever breaks into a filing system on a computer in order to acquire personal data for himself or for third persons shall be punished the same in accordance with the proceeding preceding paragraph of the present article. Part number 13 of Part 143 defines that if this crime is committed in such a manner that it affects is public, then the sentence can be stricter, and Part 4 prohibits the abuse of identity. Whoever takes over the identity of another person and under his or her name exploits his or her rights, gaining property on his her account or affects his or her personal dignity shall be punished by imprisonment of from 3 months to a maximum of 3 years. Thank you. This is for today. Inshallah, we will cover next topics in the other lectures. Allah Hafiz.